if you have lost a civil suit, you will go in appeal. Now, if in appeal, the person against whom you have filed the appeal, if he is dead, it will become your legal responsibility to substitute that dead person with his legal heirs, that is the lawful successors. Otherwise, that appeal will get abated. This is written in under Order 22, Rule 4 of the Code of Civil Procedure. And the logic behind this provision is that if you have filed appeal against someone, it means you are seeking relief from that some person. And if that person has died, you are seeking relief from no one now. So there is a need to substitute that person, to replace that person from their legal heirs. Otherwise, that appeal will get abated. Now, what is abatement? It is slightly different from dismissal. In very easy terms, dismissal means termination of the proceedings, termination of the appeal. Abatement means suspension of that appeal. The appeal will get suspended till the time the legal heirs have not been substituted. So because it is suspended till the time the legal heirs have not been substituted, it has the effect of dismissal only, because the appeal will not move forward. So today in this video, I will tell you a very surprising part, that is, even if the person against whom you have filed the appeal has been dead and you have not substituted that person with his or her legal heirs, even in that situation, the appeal will not get abated. And the appellate court will proceed with the appeal and will pass the order. And if that order will be in your favor, then that order will also apply on that dead party. Let us see how. So to understand this exceptional route, we will take the help of a very famous Supreme Court ruling, Mahabir Prasad versus Jage Ram. Although this ruling is of 1971, but it has been referred in many Supreme Court rulings, one being the latest one in 2023, Shiv Shankara versus HP Vedvyas. So now let us see what actually happened in that 1971 ruling. So the relevant part of the fact is that there are three owners: the husband, wife, and husband's mother. So these three are the owner of the property, and there is a tenant on that property. Tenant was not paying the rent. So because of the due rent, these owners have filed the suit against that tenant. These owners won the case, but there was no use of winning, because at the time of execution, this tenant has made a plea that the order of the court, which was actually in favor of this owner, was non-executable because it was passed without any jurisdiction of the court. Now the lower court, which actually passed the judgment in favor, has also accepted this plea. So now against this order, that the decree is non-executable because of no jurisdiction, the husband appealed in the High Court. The relevant part is there were actually three owners and only husband appealed, and he made other two persons, the wife and mother, as the performer respondent. In simple terms, what ideally should have happened, that all the owners should have come into the appeal, but because only one person, that is the husband, is only coming in the appeal, so other two persons was kept as the other side of the appeal, that is as performer respondent, and performer respondent is the party against whom no relief has been sought. It is a dummy party. They have no active role in the appeal. So now what happened during the appeal? The wife, which was on the performer respondent side, died. So as per the Order 22, Rule 4 of CPC, which I have discussed earlier, her legal heir should have been substituted. But husband failed to do so. Therefore, the appeal got abated by the High Court. But here is the twist, that when against High Court order, the husband went to Supreme Court set aside the High Court order, said even if the legal heirs of the dead wife have not been substituted by the husband, the appeal will not get abated. Why so? Let us see. Now, Supreme Court laid this majorly on two grounds. That is, when the appeal will not get abated even if the legal heirs has not been substituted of the dead party. Ground number one, Supreme Court has applied the provision of Order 41 Rule 4, which is another provision of CPC. It is not an exception of Order 22 Rule 4. It is just another provision, but we will use it as an exception. So this provision, Order 41 Rule 4, says in easy language that if there are multiple plaintiffs or multiple defendants, plaintiff is a person who has filed a suit against someone. Defendant is a person against whom the plaintiff has filed the suit. So this is plaintiff, this is defendant. We will take example of multiple plaintiff. For example, there are multiple plaintiffs and they have lost the suit. After losing, they will go in appeal. This provision says there is no need for everyone to go in appeal. Only one of them can go in appeal without making others as a party. Even without making others as a party, the appeal will proceed and the appellate court will pass the order. But it is only possible if the appeal has been made on a common ground or a common issue, which was applicable on all. Let us see how actually in this case the Supreme Court applied it. In this case, the lower court's order was against the owners on the ground that the decree cannot be executed because the jurisdiction, because the court was not having the jurisdiction. So this is the common ground for all the owners that the decree cannot be executed because of lack of jurisdiction of the court. And on that common ground only the husband has made the appeal in the High Court. So we can see that Order 41 Rule 4 can apply here. But the problem is, for Order 41 Rule 4 to apply, it says that any one of them should have appealed. But here what happened, the husband has appealed and made other two persons, the wife and the mother, as the performer respondent. So everyone was made actually the party in the appeal. So the Supreme Court here intervened and interpreted this provision of Order 41 Rule 4 that it will surely apply if the husband would have appealed and would not have made other two as party. But it will also apply if the husband has made other two as performer party, because he is not actually claiming anything from the performer party. So even if the performer party dies, the wife die, there is no need to substitute the legal hire, because actually the wife was actually a dummy here. Husband was not claiming anything from the wife. So there is no need to substitute her with the legal hire. When there was a need, for example, if all of them would have come as an appellant, that is all three, husband, wife and the mother, if all of them would have appealed, so now it means the wife was actually the active seeker of the relief from the tenant. And if she dies, who is seeking the relief? No one. So to fill that vacuum, there is a need to substitute the legal hire. In that case, there is a need of substitution. But if the wife is on the other side as a performer respondent, that is as a dummy party, there is no need of substitution, because there was no use of that wife in the appeal actually. So long story short, in very simple terms, the ground one was that if a decree has been passed against multiple persons and one of those persons went into the appeal on a common issue which affected all of them, the appeal will not get abated even if other persons have not made a party. Similarly, if other persons have been made a performer respondent party, and if they die, even then the appeal will not get abated even if their legal hires have not been substituted. This was the first ground. Now let us see the second ground of Supreme Court. Now the second ground was that wife was dead, husband is there in the appeal as an appellant. So Supreme Court said husband is also the legal hire of the wife. So there is no need of substitution because husband is already there. He has just to inform the court that he is in the appeal as a different capacity, but he will also represent his wife as a legal hire. Therefore, there is no need of any formal application for substitution of the legal hire because husband is also a legal hire. So on the basis of these two grounds, Supreme Court held ultimately that the High Court's order of abatement was unsustainable in law. Therefore, it set aside the High Court order and remanded back the matter back to High Court for proceedings as per the law. So this is the actual practical way in law by which you can save your cases or suits or appeal from unnecessary abatement even if you do not substitute the legal hire of a dead party. But even after having such laws, can you see a small error made by the High Court led to years of struggle by the husband? And after years of struggle, Supreme Court ultimately sent the matter back to High Court. So now it will proceed in High Court. So there is a lot of delay. So what is your viewpoint on such delays due to the error of some court in the judicial process? And in your opinion, how does it affect a litigant? I shall wait for your viewpoint in the comment box. We'll meet you in the next video. Thank you very much.